And greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. I want to remind everybody, hit that like, share, and subscribe button for me. Appreciate everybody's support. There's a PayPal link down there for anybody that wants to share some love. All is appreciated there. And of course, the StreamYard is there for anybody that wants to join the panel. We're going to talk tonight about Index Act and index funds. The mimicking of securitization at the state level and what they're doing. Kind of like the same process as a bank does when they take your document and on their side of the counter they call it an asset. Basically what we're talking about. So we're going to get into it. The first thing I want to talk about is Article 4 of the Constitution. Because like I said, they're taking certain documentation and making it an asset on their side of the counter. And that asset, this is Article 4, Section 2, it says the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or other crime who shall flee from justice and be found in another state shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed from the state having jurisdiction of the crime. Yet that's the first thing they do is they put you in the state. The part I'm interested in is that no person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from the service of labor, discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. No person held to service or labor in one state. This is your identification, folks, your state ID or your driver's license. Okay, first and foremost. And that is so that under foreign country money judgments, see, you're actually foreign, but you're a resident. You're claiming a resident. And under that resident, there's a personal jurisdiction that says a foreign country judgment shall not be refused recognition for lack of personal jurisdiction if any of the following apply. So if any of the following apply, despite being a lack of personal jurisdiction, recognition can't be refused for a foreign country judgment. Okay. F. The defendant operated a motor vehicle or airplane in the foreign country, and the proceeding involved a cause of action arising out of that operation, just getting the license or the state ID and using that as a presentment is the thing that says you're subject to a motor vehicle operator's lease. And that's what names you a defendant. Why isn't it not the plaintiff? Because it's the defendant that is looking for a foreign country judgment. If it was a plaintiff, they're operating within their own domestic rules. Okay? So they take the data elements from a foreign people in these courts, and on the other side of the counter, it's called an asset because they refuse to recognize yourself. See, again, that's because of that conversion of those Article 1 corporate courts. Absolutely. Index funds act as a proxy. We're going to be going over that. So let's take a look. This here is the Index Act. Index Act. 117th Congress, Second Session, S. 4241, to amend the Investment Advisors Act of 1940 to require investment advisors for passively managed funds and to arrange for pass-through voting of proxies for certain securities and for other purposes. This act may be cited as the Investor Democracy is Expected Act. Investor Democracy is Expected Act, or the Index Act. Investor democracy is expected. Proxy voting of passively managed funds. You know what those passively managed funds are? Those are those mutual funds, the municipal bonds. In general, the Investment Advisors Act of 1940 is amended by inserting after Section 208 the following: requirement with respect to proxy voting of passively managed funds. Definition: in this section, the term covered security, A, means a voting security, as that term is defined in Section 2A of the Investment Company Act of 1940. Then it gives you the section in which a qualified fund is invested, and B, does not include any voting security of an issuer registered with the Commission as an investment company. So you're not registered as an issuer. The term passively managed fund means a qualified fund that is designed to track or is derived from an index of securities or a portion of such an index. So an index of securities is that pooling of securities. That's why it's a democracy. 50% of them are good bonds. 51% of the bonds are guaranteed. The other 49 may not be. And it's like going to a card show or something. You go to a sports card show, and they've got all the vendors lined up with all their little different gimmicks and cards and displays, and they're doing their trading and stuff. And you come across one vendor, and he's got this table, and all of them's got a bunch of mumbo jumbo packs all put together, and they're all at $5 a pack. You never know what you're going to get in there. You might get a $50 card. You might get 10 5-cent cards. They're not all guaranteed. That's democracy. Discloses that the qualified fund is a passive fund or an index fund. So if I've got a document in front of me that says it's a financial index, then it's probably an index funded financial account. Allocates not less than 40% of the total assets of the qualified fund to an investment strategy. Not less than 40%. There's your democracy. It's got to be at least, a good majority of the strategy or the assets of a qualified fund to an investment strategy that is designed to track or is derived from an index of securities or a portion of such an index. Discloses that an allocation described in subparagraph C follows an investment strategy that is passive or based on an index of securities. The term qualified fund means an investment company, as that term is defined in Section 3 of the Investment Company Act 1940, 15 U.S.C. 80A-3. Now, an investment company, I'm sure, is described as an investment firm. See if that term is used in here at all. Nope. They do not have investment firm. They have investment company, is or holds itself out as being engaged primarily or proposes to engage primarily in the business of investing, reinvesting, or trading in securities. Is engaged or proposes to engage in the business of issuing face amount certificates of the installment type. That rental agreement, that's an installment type, and you're certifying it without knowing it. You're engaged in that type of business, or has been engaged in such business and has any such certificate outstanding. Is engaged or proposes to engage in the business of investing, reinvesting, owning, holding, or trading in securities. So if they hold you a hand you a securities instrument and you hold it, you take it in your hands and you hold it, and you put data elements in there, you've given it some kind of consideration. Is it equal as you hand it back? Is there some kind of trading going on there? And owns or proposes to acquire investment securities having a value exceeding 40% of the value of such issuers' total assets. Exclusive of government securities and cash items on an unconsolidated basis. As used in this section, investment securities include all securities except government securities, securities issued by employees, securities companies, and securities issued by majority-owned subsidiaries of the owner, which are not investment companies and are not relying on the exception from the definition of investment company in paragraph 1 or 7 of subsection C. One, any issuer whose outstanding securities other than short-term paper are beneficially owned by not more than 100 persons, or in the case of a qualifying venture capital fund, 250 persons, and which is not making and does not presently propose to make a public offering of its securities. Such issuer shall be deemed to be an investment company for purposes of the limitations set forth in paragraphs A1 and B1 of section 80A-12D1. Of this title, governing the purchase or other acquisition by such issuer of any security issued by any registered investment company and the sale of any security issued by any registered open-end investment company to any such issuer for purposes of this paragraph. Beneficial ownership by a company shall be deemed to be beneficial ownership by one person, except that if the company owns 10% or more of the outstanding voting securities of the issuer and is but for the exception provided for in this paragraph or paragraph 7, would be an investment company. The beneficial ownership shall be deemed to be that of the holders of such companies' outstanding securities. The beneficial ownership shall be deemed to be that of the holders of such companies' outstanding securities. If a company has outstanding securities, the only owners would be the investors. Are you the one investing in everything in your things and they're just betting on it? See, on their side, they're just betting. They're taking the investment. Tribe says levering assets for more credits. Absolutely. Iman says investment advisors like BlackRock, State Street, and Vanguard. Absolutely. A lot of them big corporations are investors, and this is why I say a lot of them, not even as big as you might think, but still big enough, they're taking out insurance plans, life insurance policies on their employees. It's a sick game in the stocks, folks. Managed funds suck huge fees over the life of the fund. Yep. What up, Wiz? Hello, CIA. I don't know who the CIA is, but all right. Greetings, JG. This is how they ended investor activists with voting shares. Yes, everything's now done by proxy. Yeah, absolutely. So let's take a look at the next one, or get back to it. A private fund. See, they take everything. Your data elements are fundamental. Understand that term, fundamental. Your data elements, your thoughts, your intellectual thoughts and processes in your mind as you fill out them forms are fundamental. It's private funding that you put on official documentation, official government documents, and now it becomes government information. It's now their asset. Same thing. Same thing the banks are doing, same thing. You have to learn how to qualify them data elements, folks. I'm telling you. As it relates to the trespass charge recently that they're trying to pose against me, I still need to call and talk to the city attorney. Haven't managed to be able to talk to him yet. Might be another one of those situations, but when it comes to that trespass, there's no foundation to it. So if there's no foundation to it, then they can't process it. So they have a requirement for the data element. They need the legal name, which is the first name and last name, and the birth date. That's the information they always ask for. Name and birth date, and where do you live? What's your phone number? Things like that. So when it comes down to the name, I never gave them the first name. I never gave them the last name. In fact, I made it specifically grammatical expression that it was the given name and the surname, and it was not to be taken as the first name and last name as if though it's a legal name for any contract purposes, and that I wasn't going to give them a birth date because I don't know what it is, and I was born around August 20th, 1966. So it's fundamental that you give them the right data elements, and know what those right data elements are so they can't be used against you. Anything you say can and will be used against you in a court of law. And they need that legal name and the birth date. You go around and start giving them the first or the given name and the surname and make it distinct and clarify that you know the difference, then they can't go around converting those data elements as if though it's government information. Okay? Fun fact, when you state your name for the record, they use it as a data element in the matter for trading in the markets. Correct. They have to name, and that data element is a conversion on their side, like I've said many times, and I'll show you the document as many times as you want. It says right on the financial index, and they converted the last name to the firm name. They substituted the firm or the last name with the firm name, distinctly and clarified, and then called the Social Security number the obligor number by removing the dashes. Nobody's ever been taught this stuff. That's what they're doing on the other side of the counter. Nobody. And like I said, I affirm and will stand strongly that they are Article 1 corporate courts, and you are not required, or you cannot be required to have an attorney if you don't have a board of directors to be able to hire an attorney to make that corporate representation in those courts. Can't be done. So let's get back to it. An eligible deferred compensation plan, as that term is defined of the Internal Revenue Code, an entity described in Section 3C of the investment company, a plan maintained by an employer described in Clause 1, 2, or 3 of Section 403B1A of the Internal Revenue Code of 1986 to provide annuity contracts described in Section 403B of such code, and you might be surprised to find out that that is the very thing that you're talking about with a Social Security account. Okay? You are deemed by that state ID or the driver's license to be an employee of the state. Look at the driver's license, look at the ID. It's got two names on it already. You're a third party to it. A common trust fund or similar fund maintained by a bank, any fund established under Section 834 or 8438B1 of Title V, United States Code, or any separate managed account of a client of an investment advisor. You suppose one of them clerks down there at the court is a investment advisor. I mean, they are investing. It's court registry investment system. And they are managing a separate account of a client. I mean, it is a business affair. The term registrant means an issuer of covered securities. Did you register that car? So you're the register, right? You're the one that registered it, right? The term registrant means an issuer of covered securities. So if you're the registrant of that automobile, then you are in fact the issuer of a covered security. But guess what? The certification is false. You never gave no statement of your intent. That's the indemnification documents we're talking about here recently. That's just giving them a statement of intent that if you do anything wrong in signing for these documents and stuff, your intent is to settle the matters appropriately according to the law through your ability to use the system of credits, obtaining money, property, labor, and services on credit. You're not here to cause any debts through a monetary system. You're here to use the debt system, or excuse me, the credit system. the term routine matter does not include a proposal that is not submitted to a holder of covered security by means of a proxy statement. So again, you can't, you got to give that certified statement. A proxy statement. They're operating on proxy statements, and if you don't give it yourself, they're going to give it. And they're going to put their intent down. Oh, this is my asset. This is how I'm going to use it. Comparable to that described in Section 2, A proposal that is the subject of a counter solicitation, part of a proposal made by a person other than the applicable registrant. They're telling you there are proposals made by persons other than the applicable registrant. A proposal. These are all negotiations, folks. You get to step in and negotiate. Learn how to do it right up front so it doesn't go to a proxy vote and you get screwed out of your rights, titles, interest in that property, which is the name and its use. See, this is like I've said before, this is an imperfect usufruct. And in this imperfect usufruct, I can walk around with that birth certificate and I can ask everybody around me, no matter how much authority they think they have, can you perfect this instrument in my name? And obvious, the answer is going to be no, it's not in my name. I can't do it. You have to do it. It's your name. You have to perfect the title, folks. You have to study yourself worthy and approved. You have to understand this stuff. I can explain it to you, but I cannot comprehend it for you. A proposal that relates to a merger or consolidation, except when with respect to a registrant. The proposal is to merge with the wholly owned subsidiary of the registrant. This is that reversion and merger of the estate that I was talking about as the equitable relief and remedy for prejudicial determinations already placed on the record and in error. Holders of covered securities issued by the registrant that dissent to the proposal do not have rights of appraisal. A proposal that relates to the sale, lease, or exchange of all or substantially all of the property and assets of a registrant. In election for directors or comparable positions. Any other matter determined by the Commission or an exchange registered under Section 6 of the Securities Exchange Act of 1934 to be not routine, and the term voting person means a person that provides voting instructions. See, they're telling you have the right to give them the voting instructions or give the directions. Remember 50 U.S.C. 4305 and talking about the director and here, the director here, and the director here. We're always talking about these directors and commissioners on the same mission, giving the same type of directives, negotiable instruments, negotiating peace all the way through. Not war, but peace. B, requirement. In general, subject to subsection G of an investment advisor, or if an investment advisor holds authority to vote a proxy solicited pursuant to Section 14 of the Securities Exchange Act, in connection with any vote of covered securities, held by a passively managed fund, and the voting authority held by that investment advisor with respect to those covered securities is more than 1% of the voting authority of the outstanding securities of the registrant subject to the vote, the investment advisor shall vote proportionate amounts of those covered securities in accordance with the voting instructions of A, in the case of a passively managed fund that issues securities, persons holding securities in passively managed fund, such that solely for the purposes of that vote, the percentage of securities held by such person shall be deemed to be the percentage of covered securities beneficially owned by that person. And in all cases other than a case described in subparagraph A, persons holding economic interests in the passively managed fund, such that solely for purposes of that vote, the percentage of economic interest held by such a person shall be deemed to be the percentage of the covered securities beneficially owned by that person. So it's saying that still the person that owns that document, that birth certificate, they're the beneficial interest holder. They have a beneficial economic interest in that passively managed fund to the percentage of that birth certificate for that particular pooling with other certificates. I hope that made sense to everybody. Mere voting exception for matters requiring approval of a majority of outstanding securities. This is why you're a minority. This is why you have to come up to age of majority, because like I said, they can't perfect the title, but you can. The only way you can protect that or perfect that title is by becoming holder in due course, so you can make an enforcement. That enforcement is a matter of majority. I'm an age of majority now. I'm taking over the vote. There's not going to be any more of this proxy voting shit. Notwithstanding subsection B1, B2, and D2, if a matter to be considered at a meeting of a registrant requires the approval of a majority of the outstanding securities of the registrant entitled to vote on the matter, an investment advisor to which any such provisions apply may, with respect to any covered securities for which voting instructions have not been received as of the date that is 10 days before that vote, vote the uninstructed covered securities in a manner that is proportionate to the vote submitted on the matter by all other security holders of the registrant. So if I put in a vote and anybody else that supposedly claims an ownership of any securities outstanding doesn't send in a vote, I get to put my vote forward, and the investment advisor would put my vote forward as the majority vote, in case you don't understand that. Dissemination of information, folks, and this is the very problem. If you don't understand the data elements you're giving them, you will disseminate the information into their government official documents, and it will become public information as government information as presumed until you can properly educate yourself and rightly divide the word the truth and correct those records that you've been putting in there. You're the one disseminating the information without knowing. Granted, it's not all your fault. You weren't properly educated, blah, blah, blah. We all know this, but it's time to grow up and understand there is something seriously wrong and that you got to do something different to change your world. And it must certainly come before 50 years of age for many people, I hope. My apologies. In general, any investment advisor subject to the requirements of subsection B or C, shall, with respect to the dissemination of information and other materials to a voting person, comply with the following requirements. Unless the voting person affirmatively declines to receive that information and other materials. Any investment advisor subject to the requirements of subsection B or C shall, with respect to the dissemination of information and other materials to a voting person, comply with the following requirements. Unless the voting person affirmatively declines to receive that information and other material. So who's the voting person if they're the ones entering it into their court registry investment system? Because I know I never registered to vote. A, provide the voting person a proxy statement, other proxy soliciting material, or an information sheet. An annual report from the applicant registrant, a form of voting instruction to return to the investment advisor, and any control or identification number that the voting person needs to return to the investment advisor the voting instruction provided under subparagraph B. So if I understand it correctly, the financial index document I got from the local clerk of courts from the district court down here at Blackhawk County, and it says right on it, financial index, and it says firm name, and it changed that number. I'm guessing all that information is showing me that somebody put in a proxy vote for the court registry investment system as to how much to value it and where to pool it and how all that happens. We see by the language what happens, and I'm telling you, if you start doing your research, folks, you'll see exactly how it happens in every situation. This is the same thing that happens when you go to the bank and you fill out that document and you don't know what you're doing and you hand it over to them and it becomes an investment for them. So they put it down as an asset and they provide a proxy statement to the investment advisor to go ahead and invest this document right here for 10 times as much what it says on it, and we're going to hold 10% of it back, and when we make that money back, then we can go ahead and deposit it in the account within 1 year, generally. B, provide the voting person with not less than 5 business days after the date on which the voting person receives the materials provided under paragraph 1 to return those materials to the investment advisor. So if they're taking your property as an investment, taking your data elements as the investment, is that your vote? Is that what you're actually doing when you give them that data element? Is that you're voting? Are you voting more often than you might think? Okay. So anyway, there's that one. Look it up. It's called the Index Act. Index Act. Investor Democracy is Expected Act. Index. And then the next one we're going to look at is some definitions real quick just to show you the import. I made a video earlier, a silent 2-minute video showing that the mathematical equation, folks, the mathematical equation. So you have a simple equation, x equals 4. By reason and logic, then, 4 equals x. So if you then have United States business means United States citizen, thus United States citizen means United States business, equating the exact same mathematical equation through Socratic logic, keeping things in order. Under that, we have definitions here. Oops, I didn't get that out on the screen, did I? Let me do my... So you have x equals 4, thus 4 equals x, and thus United States business means United States citizen, and therefore United States citizen means a United States business. If United States business means United States citizen, it equates the same as the simple mathematical equation above. X equals 4, thus 4 equals x. It reads forward and backward. Okay? So, the next one, set of definitions. Advisory board means a board, whether elected or appointed, which is distinct from the board of directors or board of trustees of an investment company. Now, imagine if the court registry investment system is part of the court registry investment system, then they must be involved in investing somewhere. They must have some kind of investment company ISO, right? You would think. We'll have to do some research, right? Okay. And which is composed solely of persons who do not serve such company in any other capacity. Whether or not the function of such board are such as to render its members directors within the definition of that term, which board has advisory functions as to investments, but has no power to determine that any security or other investment shall be purchased or sold by such company. Here's a doozy, folks. Affiliated company means a company which is an affiliated person. Affiliated person of another person means A, any person directly or indirectly owning, controlling, or holding with power to vote 5% or more of the outstanding voting securities of such other person. And any person, B, any person 5% or more of whose outstanding voting securities are directly or indirectly owned, controlled, or held with power to vote by such other person. C, any person directly or indirectly controlling, controlled by, or under common control with such other person. D, any officer, director, partner, co-partner, or employee of such other person. E, if such other person is an investment company, any investment advisor thereof, or any member of an advisory board thereof, and if such person is an unincorporated investment company not having a board of directors, the depositor thereof. And you've been indoctrinated to deposit all of your life and nothing else. You're the one depositing those data elements. Depositing, depositioning, okay? That's that United States business means a United States citizen, folks. Keep claiming that you're doing that. Keep claiming that's what you are. So let's take a look real quick from Investopedia. What are index funds and how do they work? Index funds aim to mirror the performance of benchmarks like the S&P 500 by mimicking their makeup. Like I said before, these courts are mimicking the securitization process of the federal government through the state's blue sky securities laws. These passive investments, long considered an unimaginative way to invest, are behind a quiet revolution in U.S. equity markets as they seize the attention and dollars of a widening swath of investors. The numbers tell the story. Passive index funds tracking market benchmarks accounted for just 21% of U.S. equity fund market in 2012. 11 years later, by 2023, passive funds had crossed above 50% of assets, beating their actively traded peers. Okay, this is the credit default swaps and all that kind of stuff. We've got the mimicking of the blue sky securities laws because nobody's signing the documents appropriately with restricted endorsements. So they go through to a second person that's putting in that, quote, proxy vote, qualifying it for their own securitization. And this is what that equity and inclusion is bringing about with this affirmative action. It's the same thing with the investments. That equity and inclusion as an investor is a cloud, folks. See, you're not supposed to be investing off the loss of another man, and that's what happens in this stuff. The only reason these people make money on this is because they're taking the loss of another man. Look at that. 21% of U.S. equity fund market in 2012. It's already crossed above 50% of the assets. Where do you think the large wealth transfer is happening? Do you think it's happening in the material gains? You wonder why the blockchain or blockchain revolution is going on? Because it's all through the passive index funds through these blockchains. Those data elements have a value, folks. The seismic shift has come as index funds have convincingly outperformed their active fund peers. According to the widely followed S&P indices versus active SPIVA scorecards, about 9 out of 10 actively managed funds didn't match the returns of the S&P 500 benchmark over the previous 15 years. Rather than having some unique stock-picking wizardry, critics argue that managers of actively traded funds have only demonstrated a magical power for extracting higher fees for themselves while returning less to clients. Whatever the outcome of these debates over fund performance, for many who once put their faith in what those fees in actively managed funds bought, the spell has clearly been broken. To see why, below we unpack what index funds are and how they work. We'll discuss the benefits and drawbacks of building a portfolio with index funds along the way. What is an index fund? An index fund is a type of mutual fund or exchange traded fund. That's why we talked about that foreign country judgment. That labor is important, folks, at the local level where you're calling yourself a resident, going down to the local plant, getting yourself a job to work 8, 10, 12 hours a day under a mutual fund or exchange traded fund. Many people are doing it wrong, folks. What are index funds? Indexes and index funds exist for almost any part of the financial market. Like Tribe was saying earlier, those data elements. Fun fact, when you state your name for the record, they use it as a data element in the matter for trading in the markets. So when it comes to the securities laws and the statistical elements on these trades. So you got a trade that's coming out from a 30-year-old young man, and it's a 30-year market. It's probably going to qualify pretty good. You do the same 30-year trade out on an 87-year-old man, it's probably going to buy up pretty good because most people in this industry will see the investment as one that's going to be abandoned. Interesting fact. So, index funds invest in the same assets using the same weights as the target index. So we have a Federal Reserve note, which is not a national currency, being used as a common index for the target index, which is the US dollar. Again, the states mimicking through the states' blue sky securities laws on one index while using another index as a target. If you're interested in the stocks of an interested in the stocks of an economic sector or the whole market, you can find indexes that aim to gain returns that closely match the benchmark index you want to track. Index funds use a passive investing strategy, trading as little as possible to keep costs low. Not only does it keep costs low, but it keeps those things hidden. See, it's like a late night gambling game down at the local club, after hours, private entrance. Yeah, you got to pay for it up front. It's a private game. It's after hours, and they can't come busting your door down. It's BYOB, or the house serves the drink because you already paid for it as a private thing. Keeping costs low by keeping everything secret. For broad indices like the S&P 500, that would be impractical or expensive to do on your own. And by the way, that's like all these people that are doing these investments in the secret. Those are, what do they call them? Inside traders? Index funds do the work for you by holding a rep sample of the securities. S&P 500 index funds, the most popular in the U.S., mimic the moves of the stocks in the S&P 500, which covers about 80% of all U.S. equities by market cap. You see why they moved into that? You see why it's picking up? Why wouldn't you want to invest in that as an investor? But again, I remind you, investing in the loss of another man is actually a sin, in my opinion, of course. The portfolio of index funds only change substantially when their benchmark indexes change. If the fund follows a weighted index, its managers may periodically rebalance the weights, their percentage by market cap, and components of their fund's securities to keep matched with the target index. Besides the S&P 500, these funds mirror other major index like the NASDAQ Composite Index, most up or made up of 3,000 stocks listed on the NASDAQ exchange, the Bloomberg U.S. Aggregate Bond Index, which follows the total U.S. dollar denominated bond market, and the Dow Jones Industrial Average, consisting of 30 large cap companies chosen by editors of Wall Street Journal. This is where the blockchain comes in for this stuff. Index funds provide broad market exposure and diversification across various sectors and asset classes according to their underlying index. This is why I say when the data elements I gave to the officer was the given name and the surname, they can't put it in their index with some kind of considered value as a legal name because it was never given any value as a legal name. Okay? It's not mutual funding. It's not mutual data elements. You cannot convert your data elements and call it a mutual fund. You cannot say it was an exchange traded. No. Those are lies. And so diversification across to their underlying index, the broader index funds are often quite good at keeping tracking errors low. See, that's what the blockchain is all about, is tracking errors. And if you're the one entering the errors, it's going to track everything you enter as an error, and they will have the ability to come back and say you're the one that's in error, you owe us a fine, this or that. When you learn how to separate those data elements in that blockchain, and remember, I've said many times, this metaverse is a dangerous place, folks. If you don't understand how it works, this metaverse is a dangerous place. Greetings, Sister Iman. How you doing tonight?
All is well, brother. All is well.
Good to see you. Good to hear you. Hope everything's been all right. Been a few.
Yeah, you said some things tonight, and I just had some revelation about a month and a half ago. Soon as you talked about that blue, yeah, revelation for real.
Yep. So let's continue on here. It says, however, you'll want to thoroughly review any funds, fees, and performance before investing. That's why it's important to understand how this system works so that we can understand what to put forth preemptively to better position ourselves to go forth in investments or as that, like I said, the indemnification private placement. To give an idea of how close the funds should track their targets, as of March 24th, Fidelity's NASDAQ Composite Index Fund had a 10-year average annual return of 15.16% versus 15.23% for NASDAQ Composite, a 0.07% difference. So it goes to the efficiency of the mechanizing financing system to begin with, that the more people catch on to this, the more people learn how to make sure that the data elements are correct, the blockchain isn't going to be corrupted, this and that, the more perfect that record is, that's going to substantiate a more economical, prosperous phase for the people. This is one of the reasons it's so inherently important to understand what this metaverse and this internet does for us. It provides a more succinct now time, both as it comes to all kinds of detriment and stuff, hurt emotions, drama and stuff. It also brings us better now time remedies and relief and cures. Benefits of index funds. The primary advantage index funds have over their actively managed peers is lower fees. So if actively managed funds don't outperform their passive peers, More investors are asking, why are clients paying fund managers so much more in fees each year? Using SPIVA data as a proxy, which compares the performance of actively managed funds with certain benchmarks, 80% of actively traded funds had underperformed. 87% of actively traded funds had underperformed the S&P 500 the previous 5 years. When you extend that to 15 years, it's 92%. So just like what I was saying just a minute ago, when you have a system that allows you a more succinct and efficient now time set of processes and reliefs and remedies and cures and stuff, you find that the longer you draw them out, it has the opposite effect. It becomes less and less efficient. A greater public understanding of statistics like these helps explain the growing popularity of passive funds, almost all of which are index funds. You still have to pay an expense ratio with these funds, which is charged as a percentage of the assets under management to pay to advisors and managers and cover transaction fees, taxes, and accounting costs. That's what they were saying up here. What was it? It was accounted for 21% of U.S. equity fund market in 2012. By 2023, passive funds had crossed above 50% of assets. And it's going to keep growing, folks. This is the transfer of wealth. And it's not as scary as you might think especially if you learn how this stuff works and get your hands in there and do what you're supposed to about it. And that's just merely settle and control your own equities and estates. Okay, by understanding what's going on the other side of the counter, you have to understand how important it is to protect your estate in all kinds of interactions. Like I said, with the police in this trespass charge, no matter how you look at it, it's a commercial venue, and there's going to be value to those data elements. And if you know what that value intrinsically is, so you can prevent them from being able to convert it for their value, you retain your value. And I'm telling you again, truth needs no defense. And once you learn the truth and its value, it will always stand in front of all of their falseness. Always. Now, the next one I want to look at, we've got banker's blanket bond. A banker's blanket bond. And I'm just going to read real quickly here. What is a banker's blanket bond? A banker's blanket bond is a fidelity bond purchased from an insurance broker that protects a bank against losses from various criminal acts carried out by its employees. When you get an account, this is one of the things you want to know from these banks. You want to know about their banker's blanket bond. You want to know what kind of policy they've got and what kind of faith they've got in their employees. And this comes in very important when it comes to equity, because that equity is dealing directly with faith in you knowing that they are competent of their job. And this is a matter of knowledge. If I'm going to go to a bank and I'm talking to a teller or a banker, a private banker, and I'm talking about the estate, and this guy don't know nothing about it, I don't have much confidence in him anymore. If he's holding my account and he's acting like this other trustee at this other bank with my companion, like he doesn't have any duty or obligation to me or my companion, then there's going to be definite issues. Such certain issues, he may just lose his job. I don't give a fuck anymore. Not one fuck. And that's why it's so important to understand how to educate yourself in this stuff. These people don't give one fuck about you, and they will just keep on railroading you because that's their job. It's your job to start educating. My people are destroyed for lack of knowledge. A banker's blanket bond is also known as a blanket fidelity bond. Some states require blanket bond coverage as a condition of operating a bank. A fidelity bond purchased from an insurance broker that protects a bank against losses from various criminal acts carried out by employees. A fidelity bond is insurance coverage against losses that stem from the dishonest acts of employees. That's covering the bank. You have the ability to put a equally considered indemnification bond up with that fidelity bond. Not just, and that's for yourself. So in case those employees violate the executive decisions that are being made and cause you to suffer loss, harm, damage, or injury. That's what these bonds are all about. But again, remember, it all comes from your credit anyway, so put it up. Everything I have up to the United States, surrender right up to the United States. Now they're obligated. Now they're obligated. They're not obligated until they have custody. Right now, it's the state that has custody. For example, go ahead.
So the only way they can really have custody over a man or a woman, they have to kidnap them because you have to voluntarily walk in. So I see why they doing what they doing.
Absolutely. And see, they don't have the right to issue securities or anything like that. Obligations and other securities of the United States. That goes to the Congress shall lay and collect taxes, duties, imposts, and excises, and the U.S. Mint shall coin and print money. See, and that's exactly what securities are. Today's money is defined as negotiable instruments, and if the states don't have the authority to print and mint coin and money, then they're technically supposed to be using the forms of the federal government, which come out from the Office of Management and Budget, and they have an OMB number on it. And they're not. Those are certain deceptive forms of some kind of foreign money, unless you're willing to put my name on it and call it my foreign money. So in the meantime, the state's using their instruments as a foreign country with their judgment, prejudicial judgment, that it has this value. Oops, sorry, wrong value. I've got a birth certificate here. It's got all this value, and it's going to clear this whole matter up. But I'm going to let the United States do it through the Treasury. United States, IRS, Social Security, Health and Human Services, Estate Recovery. Clear all the matters up straight from the enumeration at birth, wherein the state created a state's vital statistics jurisdiction and disseminated all this information throughout all these different agencies. And indoctrinated us all to believe that we weren't really supposed to be giving out the Social Security number except to certain people. So if they ask you for it, go ahead and give it to them because it's to your benefit. I don't think so. So, for example, a bank can insure a specific bank manager or choose to insure the position itself so that any employee who assumes those job responsibilities is automatically covered. Some of these types of losses that arise from employee criminal acts covered by a blanket bond include robbery carried out by an employee and forgery. Losses from fraudulent activities carried out by non-employees are also covered under the bond policy. So you can, when you're writing these things up, you have to understand what applies for your situation and how to cover it. That's it. You get to make it. You get to make your yay be yay and your nay be nay. You get to put the terms in there. That's your ultimate power of contracting. So it's merely just knowing what those contract terms and conditions need to be for this particular situation. Draw up another contract for another situation. There you go. Same thing. A banker's blanket bond is an insurance policy that provides coverage against the direct financial loss from forgery, cyber fraud, physical loss of, or alteration to property, extortion, and employee dishonesty. The employee must have committed these fraudulent acts for personal gain for the company to make any claim against the bond. This means the bond does not cover the activities of employees who commit unethical transactions for the purpose of making financial institution appear healthier. For example, losses that result from an employee that cooks the book or engages in other creative techniques to put the company in a better light than it actually is will be exempt from coverage. The blanket fidelity bond is classified as a first party coverage since it covers the institution itself, not the account holders or shareholders. However, this bond is not to be taken as a form of credit insurance. A banker's blanket bond does not extend credit or assumes the credit risk of the borrowers. Credit risk management is a component of the bank's core operations and is the sole responsibility of the financial institution. You understand that? Credit risk management is a component of the bank's core operations. Then why are they dealing in nothing but debt? Because if they deal with credit, they have to deal with the guy that's giving them the credit, that's extending the credit. Because it's not the bank that can extend credit, folks. It has to be done with a signature. And the only signature that's really needed is yours.
And see, Brother Keith, in education, they talk about you have to know your core responsibilities. A lot of these community state colleges, that's what one of the things that they push and they practice for the students to know. You got to know your core responsibilities.
Yep. And like I said, um, if you're going to be getting that ID and the driver's license or any of that stuff um, that we're finding is a major part of the problem, I urge you once again, um, don't believe me, don't believe your neighbor, don't believe the government, for crying out loud. Don't believe your mother. Do your research so you know. Um, as I pulled up earlier, oops, what happened? There we go. This is the Uniform Foreign Country Money Judgments Recognition Act for Iowa. Each state's got one. Just look it up. Uniform Foreign Country Money Judgments Recognition Act in your state, and it should come right up. Every state should have one. And it says, foreign country for definitions. Foreign country means a government other than any of the following: the United States, a state, district, commonwealth, territory, or insular possession of the United States, any other government with regard to which the decision of this state as to whether to recognize a judgment of that government's court is initially subject to determination under the full faith and credit clause of the Article 4 of Section 1. Sorry, I don't know what you missed out there, but that's full faith and credit comes from the people. The full faith and credit comes from the people. It's already been determined. Your prejudicial determination is false. Applicability. Except as otherwise provided in subsection 2 of this chapter applies to a foreign country judgment, to the extent that all of the following apply to the judgment. It grants or denies recovery of a sum of money. Under the law of the foreign country where rendered, it is final, conclusive, and enforceable. Holder in due course has the right to enforce an instrument. And under the law of the foreign country, under my word, my yea being my yea, my nay being my nay, I can render the indemnification where it is final, a declaratory judgment, final judgment, conclusive. This chapter does not apply to a foreign country judgment, even if the judgment grants or denies recovery of a sum of money, to the extent that the judgment is any of the following. So we just merely have to attach and grant a sum of money. This chapter does not apply to a foreign country judgment, even if the judgment grants or denies a recovery of sum of money, to the extent that the judgment is any of the following: a judgment for taxes, a fine or other penalty, a judgment for divorce, support, or maintenance, or other judgment rendered in connection with domestic relations. A party seeking recognition of a foreign country judgment has the burden of establishing that this chapter applies to the foreign country judgment. Standards for recognition of foreign country judgment. Except as otherwise provided in subsection 2 and 3, a court of this state shall recognize a foreign country judgment to which this chapter applies. A court of this state shall not recognize a foreign country judgment if any of the following applies. The judgment was rendered under a judicial system that does not provide impartial tribunals. The judgment or the foreign court did not have personal jurisdiction over the defendant. I have him in my custody. I have personal jurisdiction. The foreign court did not have jurisdiction over the subject matter. I do not. Did not. I have it now again because I've got the document in my possession. I'm holder in due course of the subject matter, which is a evidence of a corporate existence. That is the subject matter. Denial of corporate existence. A court of this state need not recognize a foreign country judgment if any of the following apply. If any of the following apply. The defendant in the proceeding, the defendant in the proceeding in the foreign court did not receive notice of the proceeding in sufficient time. The judgment was obtained by fraud that deprived the losing party of an adequate opportunity to present his case. The judgment or the cause of action on which the judgment is based is repugnant to the public policy of this state or of the United States. The judgment conflicts with another final and conclusive judgment.
So, Brother Keith, that would mean all court documents that are issued through these Article 1 courts would be null and void. They have to be null and void because they are deceptive forms.
Correct. For us sole individuals, yes. For heaven forbid you had an actual board of directors and you created a corporate entity and you cause some kind of loss, damage, or injury, and the state makes a claim as such, by God, you have to represent in that court. But as far as us as individuals, no, we have never been organized under 12 U.S.C. 614. The proceeding in the foreign court was contrary to an agreement between the parties under which the dispute in question was to be determined otherwise than proceedings in that foreign court. In the case of jurisdiction based only on personal service, the foreign court was a seriously inconvenient forum for the trial of the action. The judgment was rendered in circumstances that raised substantial doubt about the integrity of the rendering court with respect to the judgment. The judgment was rendered in circumstances that raised substantial doubt about the integrity of the rendering court with respect to the judgment. I've got 94 cases. And 94 cases in Article 1 courts, corporate courts, and there's not a corporate entity. I've got evidence of its existence in birth certificate form, but there's no other form after that. There's an SS5 where they gave me a Social Security card so I could then turn around and use that Social Security number to order the birth certificate, since I'm the one that can perfect that title. The one. Neo, you're the one. The specific proceeding in the foreign court leading to the judgment was not compatible with the requirements of due process of law. A party resisting recognition of a foreign country judgment has the burden of establishing that a ground for non-recognition stated in subsection 2 or 3 exists. So they have to state a non-recognition. They have to state one of these. The judgment or the cause of action on which this judgment is based is repugnant to the public policy of this state. Judgment was obtained by fraud. That's what we're clarifying. The record is showing it was done by mistake. It was done by fraud. It was a foreign judgment that isn't being recognized when it should be. It's done unconscionably without due process. Why? Because everything's being done as if though it's domestic, and it's not. It's called foreign trade for a reason. Personal jurisdiction. I'm holding personal jurisdiction. Go ahead, sister.
So isn't that where that is that called substantive procedure or it has to do with unconscionability, and I can't think of it right now, but you know where I'm going with it.
Yeah, substantive process. You gotta be able to proceed forth with your substantiations, because they can't. They don't have any business records for Keith Little. They don't have any mileage logs. They don't have any shipping logs. They don't have any bills of lading. They have no receipts. They have no business cards. They have no customer list. They have no database of anything other than the private information I've given them throughout my life that has been placed in their documents as if though it's government information and portrays a government business, a United States business, otherwise known as a United States citizen. And none of it's true. We've all been indoctrinated. There's no birth registration in the United States, so therefore there is no evidence anywhere, actually, in fact, that there is such a thing as a United States citizen unless you are registered through the Federal Reserve under 12 U.S.C. 614. Qualified and permitted to do business under the laws of the United States.
So this is the question I have, Brother Keith. What about these DHL workers, these FedEx workers, these Amazon workers? They're delivery drivers. Are they falling into those categories? Because don't they have to have some kind of a log that they have to keep for pickup and drop off and delivery of goods and services?
Well, yeah, and that's what they're doing. They've got CDLs, but for us, we don't have a CDL. We don't have a business. We don't have any records that we've been performing in a business. Those are commercial driver's licenses. It's a permit to do business at the state level for their blue sky securities laws, just mimicking the state or the federal securities.
But some of those businesses don't require them to have a CDL, just a driver's license to operate. Makes sense to me.
Yeah, it doesn't. Yeah, it's all a matter of licensing and ID, and that's just even as a resident, you're clarifying under Iowa law. It says resident determination is for income tax purposes, and that's going to be the same across the board for all the other states. It's going to be for income tax purposes, one way or another. They're going to word it some way or another that it has to do with income taxes. And with that, we come to the end of our stream. I appreciate everybody showing up and giving me some support here as I move forward with the initiation of the forensic securities audit with the IRS. Like I said, we're talking about relief in, or excuse me, equitable relief and remedy and cure by reversion and merger of the estate. So I hope everybody enjoyed tonight's stream. And I think tomorrow I'm coming back with court registry investment system. I think I did a little bit on that before, but I want to go over it and really show everybody what it's about. So I'm going to come back with that from 28 U.S. Code 2045, investment of court registry funds, and what is it else? The court registry investment system from United States District Court, Middle District of North Carolina, and one from the from here in Iowa. It's amended order regarding deposit and investment of registry funds. United States Bankruptcy Court, Southern District of Iowa. This is General Order 2016-3. And so I'm going to be reading over that tomorrow night. And we're going to be talking about that court registry investment system. Like I said, it operates just the same as the bank. They're taking something over on the other side of the counter. They know it's not theirs. They know it belongs to somebody else. They know that through certain activities in the past and a matter of record that they're just going to enter it in on their records as an asset, and it becomes an investment mechanism for them. The guy on the other side of the counter doesn't know the first thing about it, doesn't have the first clue, and that is abuse of the legal system for something it was not meant. They're using it to charge us with crimes and penalties, and on the other side of the counter is clearly being used as an investment. Let's make that clear.
Last thing, Brother Keith. Now that you're talking about deposits, now I understand they are collecting all kind of deposits from your urination, your blood, your feces,
All
all
data
those
elements.
deposits, all data elements. Man,
Yep.
that's tripped
It,
up.
yeah, it doesn't matter if it's physical or not. They're going to write it down on a piece of paper, and that becomes a data element. That is their investment, the record. And that's why I say again, they're suing the record when they foreclose on a property. They're calling back the mortgage on the address, and that's the credit part. The credit of the people is extended to the United States and shall reside as a mortgage on all property. Da 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 da. Read it. HGR 192, Public Law 7310. All kinds of documents out there tell you how this system works. Laura says, do you have videos in the electric utilities? I'm searching for more answers to give them. I don't know what you've given them so far. I do know that my first question both is, am I the, I need to, I require the identification of the first billing party who is actually obligated and their obligor number. See, what they're doing is they're passing on that bill to you. Somebody's already initially obligated on that bill. And what they're doing is they're transferring the liabilities on you. Again, if you sign those documents, you get onto the utility company and you sign this document, you fill out this paperwork to have utilities hooked up at your house, and you sign the document. It's a blank endorsement. What you just signed is a contract that can be securitized, and that's exactly what they do with it. Because on the other side of the counter, when you give a blank endorsement, what you did was you just signed, like I said, a contract that has documentary evidence of historical value and commercial value in it, and you just handed it back to somebody that can now securitize it. It's a negotiable instrument that can be securitized, and I'm not saying anybody is, but this is the way it generally does work. On the other side of the counter, that is now used as an investment. They use that as their asset. You didn't make a qualified claim on it. So in handing it over to them, you handed over rights, titles, and interest to the property, which is the name that you signed on that document. So they get to go haywire with it anytime, any way they want. It's abandoned, and they get to do whatever they feel they need to. And if that's invested, they'll invest it. So it's important to understand and learn how this stuff works. Like I've said before, if you don't know how to bank, why would you hand your banking responsibilities over to somebody else? Again, the same problem with our children. Why are we handing our children off to this public education system to have them teach them and bring them up in a dogmatic, principled set of ideas from all kinds of directions, only to have them come home and butt heads with us? It really is backwards. And so with that, we are done. You got anything on the way out, Iman? Or excuse me, Iman?
Only thing I got to say, brother, is qualified, qualified, qualified signatures, period. I yield.
Absolutely. Without prejudice, without recourse, by Benefactor, Keith. And you could even put Keith hyphen Orland, full colon, little, full colon. As long as you have that grammatical sense in there and it's represented as the beneficiary. Benefactor. And with that, we are out. You guys know me. I love you. I don't give a rat's ass whether you love me back. Let's say I don't care if you hate me. I don't care if you don't respect me. That part's on you. So may God bless you and have a good night. We'll see everybody next time. Bye now.